And joining me now to put it all in context and discuss the legal issues before the court are UC Davis law professor Vic Amar and Jane Schacter from Stanford Law School. Good to have you both with us. Well, it's finally here, almost, these oral arguments. Jane, let me begin with you. Both of these cases, DOMA and Prop 8, have to do with same-sex marriage, but they're different. Explain the differences.
Yes, they are different. The Defense of Marriage Act, called DOMA, is a federal statute. It was enacted in 1996. Proposition 8 is a California measure enacted in 2008. They're related in the sense that both of them are part of what we might think of as a backlash to early efforts to legalize same-sex marriage. And those go back even further than Mayor Newsom to 1993, when Hawaii looked like it was going to legalize same-sex marriage. Only a few years after Hawaii looked like it was going to do that, Congress got into the act and passed DOMA. And the section of DOMA that's being argued before the Supreme Court next week basically says that the federal government will not, may not recognize in any of its many programs a same-sex marriage that is recognized by the state. And that means, in terms of estate tax, veterans benefits, some 1,000 programs. Even if a couple is legally married in the eyes of its state, it's not married in the eyes of the federal government. And that's a new policy for the federal government, not to follow the states. Prop 8 only speaks to California and bans same-sex marriage in California.
Vic Amar, they are different, but they also intersect, and legally they intersect. We're going to learn a lot about perhaps what the justices feel about DOMA on Tuesday when they ask questions about Prop 8. So what are the legal entanglements here?
There are some commonalities. And as Jane pointed out, the statutes are different in that the Supreme Court could strike one down without affecting the other. There are ways to do that. But both at the procedural level and then at the substantive level, there are commonalities. Procedurally, both cases require the court to ask and answer, how do we deal with a case where the elected officials who ordinarily defend a statute, the president, the attorney general of the United States, the governor, the attorney general of a state, decline to defend? Because in both of these statutes, the elected executive officials have declined to defend. So that's a common question in both. And then on the merits, at base, the cases ask a very fundamental question of equal protection under the 14th Amendment. How skeptical should the courts be about laws that discriminate on the basis of sexual orientation?
But to be clear, they could strike down DOMA and it wouldn't allow anybody to get married.
That's right.
They could. Yeah. But if they strike DOMA down on certain grounds, if, for example, they say that DOMA violates basic rights of equality, that leaves a lot of the states that have banned same-sex marriage kind of dangling.
Yeah. There's also this question, as you said, of standing, whether and the Supreme Court in both cases has asked both sides to argue why they even have the right to be there. How big a deal is that? Is that kind of a sleeper issue?
Well, I think it is a big issue, and one of the cues we have of that is the Supreme Court specifically asked for briefing on that question and is allowing time for separate oral argument on that question in these cases. In both cases. I think the issue of standing in relation to Prop 8 is a really interesting one, because as Vic said, the Attorney General and the Governor from the get-go have not defended Prop 8. And the question is whether the proponents of Prop 8, represented by Mr. Puno, who we heard from earlier, have the right to do that. Now, essentially, the ballot proponents are private citizens. They're not government officials. They're not the people elected to make litigation decisions. So you have a situation where you have private parties who might be able to make litigation decisions and take positions for the state and have no accountability for that, nor any delegation of authority to them. But on the other hand, if those proponents don't have standing, then elected officials have an easy end run around direct democracy. So you have these two competing, clashing policies.
And of course, the initiative device was initially designed to be a check on elected officials who might not be responsive to the people.
But you can write into a proposition that if no one defends it, we can. They didn't do that.
They didn't do that, and I've written for a few years that it would be a different case had the people of California, the same night that they passed Prop 8, also formally formally deputized these folks. Because when you write that into a measure that if this passes and the Attorney General doesn't defend, then these folks will have the standing to defend, you can also answer some of these difficult questions about accountability. For how many years can they defend? How do they interact with the state, et cetera, et cetera?
Right, and there have been initiatives in California where that's specifically been written in. So the absence of that language may be significant in this case.
In the districting initiative passed in 2008 that provided for a different
political
way
redistricting.
Yeah, there was a provision that dealt with the possibility of
They probably knew the government wouldn't defend that because the politicians didn't like it. A lot of people are comparing this issue of same-sex marriage with interracial marriage.
Yeah.
And of course, in California, the ban on interracial marriage was struck down, I think, in 1947. It took the Supreme Court, the U.S. Supreme Court, 20 more years,
yeah.
1967. Like, is that a good analogy, do you think? What are the strengths and weaknesses of thinking of it that way?
One of the interesting pieces of that question is that when the California Supreme Court acted in 1948, there was basically no public reaction at all, no backlash. It's just a very different time historically. But I think one of the things we can say is a lot of the same law, a lot of the same precedents are in play. But one of the things that's different is whenever race is involved in a constitutional challenge, the court looks at that policy of drawing a line based on race with maximal skepticism and the highest level of scrutiny. And one of the things we're going to find out in this case is whether the Supreme Court thinks any kind of heightened skepticism is in order when sexual orientation is the basis.
And you know, I think race is the easy paradigm case because the 13th, 14th, and 15th Amendments, and the 14th Amendment is the one that houses this equal protection idea, they were about race if they were about anything.
It was right after the Civil War.
Right, so there's the historical case for that. But and I do think there are parallels between these kinds of discrimination, but here's another difference, and that is in 1967 when the Supreme Court in Loving versus Virginia invalidated the ban on interracial marriage, it pointed out that at that time only 16 states retained such a ban, and that in the previous decade plus, 14 states had moved away from those bans. Right now, we still have a situation where 40-ish states prohibit same-sex marriage. That may change in 4 or 5 years, but it's a little bit different kind of a backdrop in terms of which states are the outliers and which ones are in the mainstream.
Although, go ahead. Yeah.
I was going to say, one of the things that's interesting is how fast public opinion is moving.
Exactly, yeah.
So in the case of interracial marriage, actually in 1967, there were polls that show there was lower levels of support for interracial marriage when the Supreme Court acted than there are today.
Right now, yeah.
But there's still the fact that there's many states, and I think one of the reasons is there's a big regional divide.
Yeah. More so here.
On the East Coast and West Coast, there's much more sympathy for same-sex marriage than in the South and in parts of the middle of the country.
And that gets to the question of how if they strike down Prop 8, I mean, they could, of course, uphold it, but if they have several options if they decide to strike it down, and, more or less it's the California-only option, or
they can strike it down because there's certain features of Prop 8 that are problematic that aren't true of other states that ban same-sex marriage.
Right. Or there's also, I think, there's another way they could do it, which the Obama administration was recommending that would affect maybe 7 or 8 states, like other states like New Jersey and Nevada. Yeah. And then there's the 50-state solution where they just say everyone has a fundamental right to marriage, whether they're gay or straight.
The Ninth Circuit, when it struck down Prop 8, tried to craft an opinion that was particular to Prop 8 so as to keep the Supreme Court at bay.
Yeah.
And the fact that at least 4 justices thought they should still take the case suggests that maybe that wasn't an entirely successful effort. Yeah. But I don't think the court is really anxious to wade into this thicket. So something that enables it to act incrementally or perhaps duck the issue altogether, as Jane said, by pushing it off, by finding the sponsors don't have standing, may be attractive to at least some of the justices.
The interesting thing here for me is that when you pair DOMA with that's the federal policy, with the very California-specific ruling about Prop 8 that the appellate court wrote, really good just for California, that ruling. If the Supreme Court were to strike down DOMA and were to strike down Prop 8 on that basis, that would be an extremely incremental step relative to the 50-state solution.
Which is they don't strike down DOMA on some broad grounds.
Right, exactly. So it really depends how they do it. But nobody, as you pointed out, Scott, nobody will newly be able to get married in terms of same-sex couples if DOMA falls. It just goes to the federal government recognizing those marriages. So, you know, Justice Kennedy, who has written the two major gay rights opinions, may be interested in something relatively incremental. That might mean one case and not the other. If that's true, I think it would be DOMA before Prop 8.
And there's an assumption, of course, that he's the key vote, but could there be other votes from other justices in play here for one reason or another?
When I listen to the argument tapes, I'm going to be wanting to see what Justices Kagan and Chief Justice Roberts and Justice Breyer, who could also be incrementalist bellwethers, and I'm not sure that they're ready to take this step. They might be.
The step of going beyond California,
or even invalidating
California.
I mean, let's not forget, invalidating a law in the biggest and most important state in the country on grounds that you try to limit to California, but that have a way of creeping out and affecting other states is not a trivial thing.
Well, you know, we live in this bubble here, a liberal bubble in the Bay Area. There's a lot of opposition to Prop 8 here, but how heavy a lift is it? How big a deal? And it kind of goes to what you just said, Vic. I mean, we shouldn't assume that they're going to strike Prop 8 down.
No, we certainly shouldn't assume that. I mean, it would be the first federal ruling in favor of same-sex marriage if they were to do it. And the California specific quality, I think, is of an opinion that might be written is undercut by the fact that California is often a bellwether for other states.
Yeah.
And Scott, you mentioned these national opinion polls, but as Jane said, it's very regionalized. So, you know, it's not as if, you know, there's going to be same-sex marriage in all 50 states anytime soon, but we still might have significant change in the next 3 or 4 or 5 years, such that the court might want to wait. And if it has means open to it to kind of push this issue off for a few years, the backdrop against which it decides these questions may be a little bit different 4 or 5 years from now.
Short on time, but what are you going to be listening for?
I'm going to be listening for what Justice Kennedy has to say, and I'm going to be listening for what they think about the rapid change in public opinion and the fact that the political process is engaging with this issue.
They'll be talking about that?
Well, I think that might be a reason why the court stays out of it. On the other hand, if the court isn't talking about that, it still might be affected by it in the sense that they may view the issue differently today than they would have 10 years ago.
And we will get the audio tapes about 3 hours after that. It's kind of unusual. They realize, obviously, this is a big deal, and people are lining up already.
Sure.
On Thursday, they were lining up to get into the court. So we look forward to that, and obviously much more to talk about. Jane Schacter from Stanford, Vic Amar, UC Davis. Thanks so much for coming in.
Thank you.
We'll be following it, I'm sure.